Hi guys, it's Kathy. I hope you're doing well. So we stopped that video yesterday because we were streaming for 2 hours, so it was time to stop anyways. Perfect breaking point. But KS told me that, oh, he does get on the stand. So we're going to continue that video where we were, and he's about to get on the stand. So they're doing some motions right now to suppress. And then I think they go right into it, and I do not know what it is. So I didn't watch it like I said I was going to. I got a little busy with other things. But let's go. Let's get into this. Let's do this. There he is. See what he says to the judge. If he says anything. I don't know. Oh, that's right. I should forward it until the judge is on the screen. Never mind.
All right. Defense, you may call your witness.
Yes, Judge, we're calling Ronald Lamar Allen.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand. If you'll state your name for the record, please.
Ronald Allen.
All right. You may proceed.
Mr. Allen, why did you say what you said in that recording?
Because I felt like the judges and the lawyers weren't taking this matter serious enough. I think that they were the reasons why my cousin committed suicide. And I believe that all the violence and all the murders that are with the family cases are because of they're toying around with it. And I think that there's dead bodies everywhere because of it. Every family situation, a murder suicide I see on the news was related to a family dispute gone out of control. And that's what I was referring to.
And how many times have you been in the civil court?
That was
236 times.
And that's how many temporary orders and settings that have been made?
Yes, sir.
236
Objection,
times?
Yes, sir.
Leading, but also this is outside the scope of this hearing. All right. That will be sustained.
Do you possess any firearms?
Nope.
Other than your ex-wife, has anybody else ever accused you of being violent?
Nope.
Objection, Your Honor. Relevance. Sustained.
What are your feelings towards Mr. Ireland now?
Objection, Your Honor. Relevance. All right. How is this relevant to the motion to suppress? And I understand the rules of evidence and that privilege, communications of privilege. I understand how that relates to motions to suppress. And I understand that technically the rules of evidence do not apply to motions to suppress outside a certain number of rules. But with regards to this, how is this relevant to anything about the motion to suppress?
I think it's worth it for Mr. Allen to be able to say how he feels betrayed by his civil lawyer.
All right, that'll be sustained.
I love her.
How many other civil lawyers have you had?
At least 20 something.
How is this relevant? And this is outside the scope. All right, that'll be sustained as to outside the scope of the hearing.
Well, Judge, I think that's kind of a hard item. I mean, we've acquiesced to let him testify in this suppression hearing because we think that he has an expectation of privacy regarding his communications with his own lawyer.
Then you ask that question.
All
He
right.
should be able to talk about that, we believe.
Well, with regards to his expectation of privacy, because I'll note for the record, this hearing is a combination, I believe, of the motion to suppress and the motion to dismiss. So I will take this hearing as a combination of your motion to suppress and the motion to dismiss. Is there any objection from either side to the court hearing evidence for both of the motions at the same time?
No objection from the state.
I'm not opposed, Judge.
All right, if there's no objection from the state and the defense, then because you all are saying that you want the motion to suppress and then the motion to dismiss heard at the same time, then I will hear testimony from the witness with regards to your question of expectation of confidentiality.
And we think that's the efficient route.
Okay. All right, you may proceed.
Mr. Allen, you've had so many different lawyers on your cases. Have any of them ever disclosed confidential information to the opposing counsel, to the representative for the child, or to the court generally?
The state is objecting to relevance outside of the scope. In support of that, we're talking about representation from other people. This is not relevant, and it does not go to what Your Honor has narrowly allowed expectation of confidentiality. This is outside the scope.
All right, so counsel, that objection does not pertain to your motion to dismiss or to the motion to suppress. So response
Well,
as to what other attorneys did.
I think it is relevant because it tends to, we're talking about an experienced person in relation to attorneys and what kind of expectations that he has regarding privacy and what is typically contracted in a civil attorney contract.
Right, well, you can question him about his
Ask him.
expectation of privacy as it relates to Attorney Ireland.
Okay.
All right.
Did Ireland ever call you and ask you anything about your statements made in the office and the recording we heard?
No, he did not.
Did Ireland ever tell you that he was going to call the amicus attorney or call the police regarding what you said?
No, he,
Objection, Your Honor, relevance, but also an appropriate witness. We had Mr. Ireland on the stand and all these questions. There's a better witness for that.
He's a party to that conversation, Judge.
All right, I'll let you, and I'll let him answer the question.
no,
Did Mr. Ireland ever ask you what you meant in that moment?
no,
Did Mr. Ireland ever express any fear or recoil? Did he act scared when you were in that meeting with him?
no.
What were the last things that Mr. Ireland told you at the end of that recording?
Get out of my office.
Yeah. When Mr. Ireland said that you were getting effed, did you think that he meant that you were literally going to get effed?
Objection, Your Honor, relevance. This is beyond the scope, and those are the state's argument.
All right, beyond the scope of the motion to suppress or the motion to dismiss?
This would be for both. They're talking about what words mean or should mean or literal meaning, and it has no business in either the motion to suppress or the motion to dismiss.
All right, that objection will be sustained. You can ask your next question, counsel.
What do you expect when you walk into an attorney's office?
What do I expect when I walk in? Well, confidentiality, of course.
Do you expect that the attorney's going to be on your side?
Absolutely. Or you sign a contract with them. It's there.
And did you ever try to get, did you ever try to hire your wife's lawyer?
Objection, Your Honor. Relevance.
Sustained.
Would your comfort, would you, when you talk about dead bodies, would you have that kind of conversation with Ms. Hesbrook or with the opposing lawyer?
Objection, Your Honor. Relevance and outside the scope.
All right, that'll be sustained.
Man, this attorney's dying.
Did you have any means to execute any kind of threat?
No.
Did you have any kind of intent to threaten anybody in the courthouse?
No.
Did you have any intent to threaten Mr. Medley?
No.
Did you have any intent to threaten your ex-wife?
Objection, Your Honor. It is beyond the scope of both motions.
Our motion to dismiss talks about mens rea and the intent and the mind of the accused. And so I think if he's taking the risk of subjecting himself to a cross-examination from Mr. Duffy, well, then he can ask his questions as much as he wants
Well,
on
what-
redirect.
What I can tell both parties with regards to mens rea and whether or not he had the appropriate mens rea, that is really for a jury to decide and not for the court to decide whether or not he acted knowingly, intentionally, unless you all are coming to the court for a bench trial. Otherwise, that's
not what
really
this is.
within the purview of a jury.
Right, Judge. We're agreeing to move forward for this on a suppression.
Mhm.
Mr. Allen is agreed to give his testimony regarding the suppression and the dismissal motion, but he's not giving his consent to be heard in front of a jury right now.
No. I'm just saying
That's
that
the problem.
the mens rea part of it,
Mhm.
that would only come down to, jury trial or a bench trial, not for necessarily a motion to suppress or for me to determine in a motion to dismiss whether or not he exhibited the appropriate mens rea.
Okay,
That would be the state's argument, is it's outside the scope of this hearing and it should be a matter for the trier of fact.
All right.
fine.
So that objection will be sustained.
Mr. Allen, what's your understanding of free speech in the United States?
Then you have the freedom to speech, exactly what it means.
And do you think that that your attorney's office is a location where you can execute that right?
Objection, Your Honor. Relevance, but outside the scope as well.
All right. That'll be overruled. I'll allow him to answer that question.
Why?
Because one, it's America. Number two, it's because when you talk with your lawyers, those would be in confidentiality.
Is it because you're making plans with your lawyer regarding the tactics that you're using in the litigation?
Absolutely, hence the confidentiality.
Would you want the other side to know? Would you want your wife's lawyer to know what you've talked about with your lawyer?
Objection, Your Honor. Outside the scope.
Sustained.
Mr. Allen, why do you think that the court should suppress the audio recording made by your prior lawyer?
Objection, Your Honor. Speculation, but also calls for a legal conclusion to which this witness is inappropriate.
Sustained.
Is he even a lawyer? Is he a lawyer? I don't know.
In that recording, you were expressing some fear, frustration, and using some of this language. Was this, and this is a question, was this something that you had a plan, did you think that you were committing a crime by going in and talking to your lawyer about these things?
Objection, Your Honor, relevance and speculation.
All right, that'll be overruled. You can answer that.
Did you think you were committing a crime when you went in?
Absolutely not.
I'm gonna pass the witness.
All right, state.
That was a great question, sir. Good job.
Just a brief moment, Your Honor, sorry. Your Honor, the state has no questions.
All right, you may step down. Cindy, don't forget your microphone. Any other witnesses?
That's it, Judge.
State any further witnesses?
No further witnesses from the state, Your Honor.
All right, then we'll
I'll
close the
adjourn.
hearing and we'll come back tomorrow morning and I'll hear arguments on both motions.
Shall we expect that to be at 9?
It depends on when he gets here. All right. All right, thank you, everyone.
Thank you, Judge.
Doesn't want to face reality. He is no longer with us.
I'm not sure, but I think that somebody was murdered. But this doesn't look like their lawyers, right? This is the very next day.
Oh. Vashawn got on us for splitting the poll.
And that doesn't look like his lawyers.
He wants you to, he would like to address you
So-
about the motion to yesterday.
I'm a full-time dad. I don't work all the time. And the reason why I'm in trouble right now is because
So it must be this one right here.
I'm sorry, it's taking a little bit while for Odyssey to open documents. for
Where
me.
is he?
not see him on our doc.
This is someone else. I know that
Thing,
they.
you know, you're the first.
So I got a message from KS yesterday around noon. Closing arguments are now. So I know something happened. I just don't know where to find it, guys. So this is the one we finished today. So it has to be one of these two.
Doesn't want to face reality. He is no longer with us. I look at all his pictures and think of those precious moments we
Could
had
this
with him.
there's he
And
is.
realize no more memories
him?
will be made. I then
Right,
realized
I'm just
I
gonna
will never
go
see
to
no
this
more
part.
skate videos.
All right, you're welcome.
Right here. It has to be right here. This is 16 minutes in. They don't really have clocks, so I don't know what time it is. Time doesn't mean anything. Like, Donald, you told me it was at 8:30 yesterday. I looked. I don't know what 8:30 means. I didn't find what you were telling me about. But he had a couple videos yesterday, so I might have been on the wrong video. Oops, that's not me.
I remember that.
I was not here for that. Thanks.
All right, who's here on Lamar Simmons?
I am, Your Honor.
Donald, I did make a video off of him anyway. Oh, see, there's no time on a YouTube video. So you if you tell me what time it is in real life when something happened, I can't really look for that. I can't scroll for 9:30 on here. There's no way to do it. However, I did get that school bus. That guy who passed the school bus and was killed those 2 kids. I did get that.
I'm covering that for Joanne De Hoyos.
All right, are they on bond or in custody?
I verified they're on bond, and prior to putting bond, I had done a back to the letter to the jail.
Mhm.
I know he's with the company bond, but we faxed a letter to the jail. There's no way, couldn't get that letter with our contact information. And
Norma, this courthouse tour, I've already responded to it. I told them we could have the courthouse tour, but it has to be Donna Ramos. Could I have parties announced, please?
That's all, Ms. Miles.
Adriana Ramos.
All right, so it is the court's understanding that your attorney has filed a motion to withdraw. Are you aware of his motion to withdraw?
Yes.
All right, so I don't do ex parte. However, managed assigned counsel just sent an email to the court coordinator, and the court is in receipt of that. Any objections to the court reviewing what managed assigned counsel has sent?
No, Your Honor.
All right.
No, I wasn't making you say
All right.
sorry. I'm happy.
So the email
I'm happy you sent me that. All I'm saying is I couldn't find it. I didn't want you to be wondering why I didn't play your clip. It's because I couldn't find it. I looked and I didn't see it. I did see, was it Fozzie who posted something? I don't know. So other people did see it. I just didn't. I wasn't able to find it.
has been sent to me, and I want to explain to you, Ms. Ramos. Normally, I do not allow motions to withdraw just because there's some sort of lack of communication, but based upon what managed assigned counsel has sent, I will grant the motion to withdraw. All right, you may be excused.
Be available for the next council with any questions, Your Honor.
All right, if you will just remain in court.
Y'all will.
Thank you. So then the next question becomes, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Amen.
All right, you can lower your hand if you'll state your name for the record.
Adriana Ramos.
All right, so Ms. Ramos, the questions I'm going to ask you, it has absolutely nothing to do with the facts of your case. Please do not tell me anything about the facts of your case because your attorney would not want you to, okay?
Yes, ma'am.
All right, so are you able to afford a new attorney?
No, ma'am.
All right, do you have any funds in a bank account, any savings?
Not really. My mom just passed away in May, so
Mhm.
I just had to bury her.
Okay.
I do have a job at AutoZone, but it's part-time.
Okay. So do you have any money in a savings?
No, ma'am.
All right. So I'm going to have a new attorney appointed to you, and that new attorney is going to be Orlando Castillo. All right. So if you'll confer with him.
Yes.
All right. She said today, we're off the record. She says today for it's just discovery today.
Okay.
So that's what we're here for.
Okay.
So he'll confer with you, and then he'll confer with the state, and then he can approach me when you're ready.
Yes, sir.
All right, you're welcome.
See outside.
Hi, Chaos.
All righty. I'm gonna give this back to you, but don't follow the way. They're gonna approach when they're ready.
I think they should say no.
So everyone else, if your attorney is not here, you need to pick up the phone and call them.
No. I think when you get appointed a public defender. That's your public defender. And you don't get to pick and choose. You just don't get to. All right. Sounds like I need to bump it forward a bit. We'll find it, guys.
Because we're going to be recessing and then we're going to have a jury up here for whoever wants their jury trial.
I know, she had a whole photo shoot.
Oh, and she's over here doing yoga poses. Christy Riojas.
Did you see the donkey? I don't think Christy Wheelhouse is part of the trial. Maybe she is, though. No, where's the defendant? He's not here.
She is bringing joy to the courthouse. And then Deputy Laura Scott's client, but I know you have to do them separate.
Okay.
Attorney here for Jesus
It's not here.
Enrique Alexander Velasquez Jr.
It's there. There's nothing here. Hold on. So this is a 3-hour and 26-minute video. That's not it. There's nothing in there for this court, for this case. So this is the only one left.
Person who's been on the jury and French is their first.
Judge, do you want me to lock the door? Or just
Yes.
wait? Let me go.
Carlos Perez. And knowing that, do you still wish to proceed with that change? Did you review the court admonishments with your, what's the judge's last name at least? Now, you probably say, lady, we know, we've been standing outside looking at your door. When are you going to let us
Okay,
in?
but
The reason
where?
why I
In this
asked that
video?
question is because sometimes
It can't be in this video. There's nothing in this video, right? They're standing in front of the judge. Oh. But, all right, I'll go back to the last video. It has to be in the last video. Has to be. What do you mean? How are they going to have a trial standing in front of the judge? Okay.
what will happen, I don't know.
I don't know, I'm going to find out.
What will happen, like, hey, he's like, no. He's like, what? So
That's not him.
But
he's going to jail.
Good morning.
Nothing's going on. Okay, there's something.
all right, Mr. Kawazawi.
We're starting right from
So
here.
you have persons here who want to address you. I require that everyone treats everyone with respect. So just listen to them, internalize what's being said. Do you understand? To everyone who's going to be speaking, there's not to be any outbursts by anyone. Otherwise, you will not be allowed to continue to speak. Does everyone understand? All right, so you may proceed. All right, just give me one moment. Don't print anything during victim impact. All right, you may proceed.
Losing our son has been my hardest goodbye. I relive the moment I received that phone call every night. My mind doesn't want to face reality. He is no longer with us. I look at all his pictures and think of all those precious moments we had with him.
Okay. So I went back to 2. Well, it's almost 2. I don't think it's at 2:16. I think you should try again because just maybe. Is this it right here? We are at 2:21 right now.
Locke,
So
you are here first, so your case is gonna be taken care of first. Or did I just jinx that? I'm sorry.
Yes.
I jinxed him, didn't I? It's sort of like when you walk over somebody when they're laying down. They used to always say that's gonna mess with their height. And so you would have to walk back over them backwards. Oh,
do you just tell me 2:00? But there's no clocks. I don't know what time it is. There's no clocks in her courtroom. I'm gonna go try to find that victim impact statement we were just listening to. It should be right around there.
Realize no more memories will be made. I didn't realize I would never see no more.
2
state videos, which was
hours.
his passion.
Gotcha.
I will no longer hear his voice, his laughter. I will never see him smile. Throughout my son's 20 years on earth, we have never been separated. Not a day, not one day went by we didn't talk or text. I feel so lost without him. My son Johnny was truly a miracle from God. We struggle a lot with him health-wise, and we had overcome all odds as a premature baby. Sometimes this pain is so unbearable, I can't even get out of bed. It has been a struggle for me to go on.
I like
It
him.
has me questioning my faith. Why him? My boys were my world. They were my reason for getting up every day. They were my inspiration for life, my greatest accomplishment. I feel so defeated. A week before my son was taken away, he texted me this point. Somewhere between then and now, it went from mom, stop telling me what to do, to mom, please tell me what
Is
to
she
do.
for
Somewhere
for
between
the
then
case
and
we're
now,
watching?
it went from mom, you don't understand, to mom, I don't understand. Somewhere between then and now, it went from mom, stop asking.
These victim impact statements right now, is this for the case that we're watching? Or is this for a completely different case? Because this is murder. This lady? Yeah, she's the reporter, I think.
To me so many questions. To mom, I have so many
Yeah,
questions.
right here.
Somewhere between then and now, it went from mom, leave me alone, to mom, never leave my side. Somewhere between then and now, I realized the other half of my heart was always the person who created it in the first
Okay.
place.
These
It killed
victim
me.
impact statements have nothing to do with us. This is what it has. Let me just go to the 2-hour and 16-minute mark. There we go.
hello, Mr. Allen.
Hello.
Medicare, yes.
Just
Thank
give
you,
me
Jazz.
one moment. All right, if everyone can please whisper, we're gonna go on the record. Court is calling 2025 CR 007563, State versus Ronald Allen. Could I have parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Charles Butcher for the case.
All right, and are you Mr. Allen?
Yes, I am.
We were here yesterday. The court heard evidence on defense's motions. The court ordered or requested that both parties be present today to make their arguments. And so defense, it is your motion. So, and both parties agreed for the hearing that they would combine the motion to suppress and the motion to dismiss. The court asked well, requested if both parties would agree to combine the motion to dismiss and the motion to suppress due to objections that both parties were having to particular evidence. And some of the objections with regards to the motion to suppress were not appropriate for a motion to suppress, but they were appropriate in the motion to dismiss. So that is why both parties agreed to combine the two motions. So with regards to the motion to suppress, what I would like to start with is we'll start with number 2, where the defense's argument is there's no probable cause. You may address that, counsel.
Judge, regarding we did hear testimony from Mr. Allen, Officer Che, and Attorney Ireland. We heard Attorney Ireland's recording. We'd seen the state's theory take its full shape. The reason we think that this lacks there's a lack of criminal conduct on this matter, because from the outset, the prosecution relied on a paraphrase quote allegedly said by Mr. Allen, which was, "If I don't get custody, I will make history and there will be dead bodies everywhere." But when we heard the recording, that phrase was never heard by the court in the recording submitted by Mr. Ireland and played for the court. The actual statement made by Ronald was, quote, "So if I was gonna do that and I knew all this stuff was gonna happen, period, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro." Later, he says, because if they don't get busted, there's going to be dead bodies everywhere. Now, our contention is that neither of these statements includes an assertion of personal action on the part of Mr. Allen. There is no named victim. There is no identified target. And there is no expressed intent to carry out any kind of violence. It's also troubling that the DA's office or Detective Che did not fully review the audio, but simply adopted Mr. Ireland's paraphrase as fact. I think that this misstep undermines the reliability of the charging process and bolsters the necessity for judicial correction through either suppression or the dismissal.
All right, and with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat that there will be bodies?
Well, I think a part of this is the nature of the charge is that this is a terroristic threat on a public servant. Although other public servants are discussed in the 12-minute recording that we heard, none of those public servants are specifically targeted in any of the statements that Mr. Allen made. They're talking generally about a number of things related to the legal strategy, related to the tactics that are being used. And basically, my client is speaking freely to his own lawyer.
All right, but I'm reading the indictment. Is there any objection to the court reviewing the indictment?
None from the state, Your Honor.
None here.
All right, so I'm reading the indictment, and the indictment reads that on or about April 21st, your client did threaten to commit an offense involving violence to a person, namely, and then it says to kill people with intent to place the public or a substantial group of the public in fear of serious bodily injury. So according to the indictment, it's saying a group of people and not necessarily a person who's a public servant.
Of course, Judge. We do recognize that that's what the indictment says. We accept that that's the indictment generally, but we do have issue with the idea that this statement has been taken out of context. He's not particularly naming that he's going to do anything to the court or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years and I work in this courthouse every day. And I don't feel like Mr. Allen is a threat to this court either. Further, when we talk about this, Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. he was not emotionally stable at that point because of the difficulty that he was having with his custody matter. So he was also shocked to learn that the words that he mentioned in his own lawyer, where he has an expectation of privacy, were being recorded and being used against him to third parties.
All right, so do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with exceptions.
Exceptions, yes. All right, so do both parties stipulate?
The state stipulates.
All right, so then the next question I have of both parties, is there an exception? And I think both parties know the answer to the confidentiality if there is a threat of violence or if there is a threat of a future crime.
Yes, the state is aware.
All right, and defense, do you stipulate to that?
Yes, Judge, we do know that there are rules, Rule 105C7 of the ethics rule provide for permissive disclosure to prevent criminal acts. And we anticipate that Ireland would be arguing that he had discretion under this section if he reasonably believed the disclosure was necessary to prevent a future crime. However, according to those rules, the comments inside of those rules, comment 13 to 14 in the rules that are promulgated by the state, the magnitude, proximity, and likelihood of harm must be weighed. The threat must appear imminent and grave, and the disclosure must be no greater than necessary. The problem here is that Ireland disclosed everything and voluntarily handed over a recording, and that recording was not narrowly tailored as a warning. And then we have his own testimony where Mr. Ireland gets on the stand and he tells us, also in the recording, "I'm not afraid of anything regarding this case." That contradicts a reasonable belief of a grave and imminent harm.
But counsel, wasn't his saying he's not afraid of anything about the case in reference to the pending civil case, not the alleged actions that we're here for today? I thought that's what he testified to.
Well, and I do know that what we're really talking about is that Mr. The lawyer that testified, that was this man's lawyer. He continues to try to expand and express that he's in deeper fear than he was in the moment, and I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately called the amicus attorney. He thinks he doesn't remember that, but we believe that he called the amicus attorney because we got a bill for that. And then further, he calls the Texas Bar Hotline, which is going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
All right, so let's start here. The first thing is that the court finds through stipulation, and I think both parties know, that when someone is speaking to their attorney about legal matters that they've been contracted to do, that normally it's privileged. But I think both parties have also stipulated that there are exceptions to that privilege. And one of them is if there is a threat of future criminal activity, or if there's a threat of harm to anyone else. So let's start. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense, whether or not that was privileged?
Yes, Your Honor, that was not privileged communication. It is detailed in the exception for furtherance of criminal activity, express or implied intent by saying, if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies, implied, maybe the how. But this was not privileged communications between an attorney and a client. And no, the shift of the communication that you heard, the audio recording, that statement comes at like minute 10:45. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. So to say that the attorney, Mr. Ireland, wasn't scared, that was at minute 4. And Your Honor was correct in assessing that that was not related to the future threat that was going to come 10 minutes later, 6 minutes later. That is not privileged communication. Those privileges are to ensure fair trial, trust between parties. The privilege is not intended to grant people a right to threaten and to use words to cause a reaction like what happened in this case. It's not privileged.
All right, so the court is going to find that there has not been a violation of the attorney-client privilege under the Disciplinary Code 1.05C7. The court is finding that the recording is not illegal as Texas is a one-party consent state, and the attorney knew that he was recording and he was a part of the communication. There was no third party in the room. It was Mr. Allen and his attorney. Now, with regards to the warrant requirement, both parties stipulated that this was that the defendant was arrested under warrant. So there's a warrant requirement that has been met with regards to that. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of your motion as well, client, Mr. Butcher.
Yes, Judge, that goes towards the motion to dismiss regarding this. I think there's some particulars in the recording and in what was discussed with Mr. Ireland on the stand. There are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. First off, Mr. Ireland said, you can fire me if you want. If you think I'm not doing my job, then go ahead. I think the implication from that is that Mr. Ireland had a calm and professional demeanor and he was not in fear. Further, Mr. Ireland said, you're getting F'd. In that regard, he's aligning himself with the client emotionally and tactically. And I think that matters because he's continuing to engage in this as not somebody that's looking for a criminal intent, but he's looking for a way to align himself with his client and think about the custody case strategically and tactically. He even says, I agree with you when Mr. Allen indicates that he is concerned and afraid because of some coincidences that were happening in that litigation. Further, they even talk about subpoenaing a gentleman named Sherwood. So Mr. Ireland is strategically engaging regarding the subpoenas that he's going to issue and the work that he's going to do in furtherance of that custody case. Now, I realize that this court isn't about reviewing a custody case in any way, but what we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen testified that he believed he was speaking confidentially with his lawyer. He had no intent to harm anyone. He was emotionally distraught, particularly due to the custody losses, and he was shocked to learn that his words had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, I'm scared for my life, dude. That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases that are constitutional cases, and one of them is the Watts case. In the Watts case, in a 1966 anti-draft rally in Washington, D.C., an 18-year-old draft dodger made the following remark, quote, if they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ. This, by the Supreme Court, was interpreted as a threat This was interpreted as a threat by the authorities under the United States Code regarding terrorist threats toward the president. But the Supreme Court found in 1966 that they reversed the conviction, holding that Watt's statement was political rhetoric and not a true threat, and therefore was protected speech under the First Amendment. Now, this applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to inflict harm. So hyperbole, exaggeration, or emotional venting, even if it's crude or alarming, doesn't qualify as a true threat. Lower courts later differed on the objective versus subjective standard on this, but Watts did emphasize the importance of both context and intent. In reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric that Mr. Allen was engaged in. Similarly, this case, in Ronald's case, it was emotionally charged, but it was conditional, and it was made during a private dispute involving custody. Now, Texas courts regularly apply the Watts principles. There's another case called Lopez v. State, where 631 Southwest 3D 107. In that case, the court explicitly cites the Watts case in evaluating whether a defendant's statements were true threats or protected speech. And in that case, it was held that the defendant's statements about bombing a school were not protected speech because they were specifically targeted and intended to be taken seriously. But the key takeaway on that is that Texas courts always adopt the contextual approach from Watts, looking at the surrounding circumstances, the intent, and the audience. In this case, those factors are highly in favor of a dismissal for my client. Further, there's another case called State v. Hansen, where the courts recognize that political hyperbole, even if it's violent in tone, may be protected under Watts. There's also the Dorset v. State case, where a defendant told officers, "Y'all better wear your vest because I'm going to start shooting." This was held as a true threat, but only because of the content, including a history of violence and the ongoing criminal conduct resulting in the officers responding in that case. Watts influences Texas law even without being codified. Texas courts do adopt some options of Watts because they talk about a true threat test as a conditional limitation in applying the Criminal Code 22.07. The judges are to act as gatekeepers even if the conduct appears to violate the literal text of the statute, but it must pass the Watts standard in these matters. There's another case, more recent in 2015, the Alanis v. United States case, where the Supreme Court held that punishing threats require proof of a mens rea or a subjective intent to threaten. The person cannot be convicted. The Alanis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend for those words to instill fear or communicate a threat. In this case, the full transcript demonstrates Ronald's alleged threat was embedded in an extended stream of anxious, erratic speculation and emotionally charged grievances, where at one point Ronald even says, "I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen." He further elaborates, "Hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls." When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. So here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alanis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard, and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention, and the state hasn't shown that his intention was to make a threat
But
to the general public.
at this juncture, isn't whatever your client's intent, that's something for a jury to decide? Or if this were a bench trial, then it would be for me to decide. But is that correct? That that's something for the jury to decide whether what his intentions were. At this point, my only, based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. It falls underneath the exception. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something for a jury to make that determination. At this point, this court, I'm just making rulings upon motions that are presented to me. But there are some things that I legally am not allowed to make rulings on. One of them is determining what your mens rea is, you know, whether it was intentionally, knowingly, recklessly, whatever it may be. And that would be what is actually in the indictment. So in the indictment, it's they're stating that you made a threat with the intent to place the public or a substantial group of the public in fear of serious bodily injury. So at this point, for this hearing, it is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right? That would be something that a jury would decide. Now, if you were having a bench trial, then I would be in the place of the jury, and then I would listen to evidence and make a determination of whether or not I believe beyond a reasonable doubt that the state has met its burden based upon what's in the indictment. You understand?
Yes, ma'am.
So what I can tell both parties is that, one, there was a warrant. Both parties stipulated that a warrant was issued. Number two, the court is finding that while your communication with the attorney is confidential and private, right? But the
What do you mean,
exception to
Kat?
that, one of the exceptions, if there's a threat that's being made. So the communication, the court is finding the communication that you had with your attorney, the court is finding that that falls under the exception of attorney-client privilege. So, State, you want to address the defense's other points, please?
Yes, Your Honor, we would start with point number 5 in the motion to suppress, that the statement was not a true threat. The state is offering to the court and to defense what is Garcia versus State, 583 Southwest 3D 170.
Thank you.
All right, and I'm aware of the case, but I'll review it. So thank you.
Judge. I have flagged a couple important spots. The First Amendment does not protect speech like this. A true threat, and Your
Does
Honor,
not
you will
protect
find this,
speech like
I
that.
believe, on page 2, that first flagged one. True threats encompass those statements by which the speaker communicates an intent to commit an act of unlawful violence to a particular individual or group of individuals, regardless of whether the speaker actually intends to carry out the threat. And this Garcia case quotes a Supreme Court case, Black 538 US, and that's at 359. The reason that the First Amendment does not protect violent speech like this is to promote public safety and curb misdirection of resources. When defense brought up Watts, that is specific to the draft. And the gentleman in that case didn't know if he was or was not going to be drafted. So it was hypothetical, hyperbolic. In this case before the court, we heard the recording on Wednesday, 3 times, Wednesday, Wednesday, Wednesday. When the defendant talks about dead bodies everywhere happening on Wednesday, I'm gonna make history. This is not hypothetical. This is distinguishable from Watts. The defendant here is making direct threats. Now, this language is not ambiguous or exaggerated. If X, then Y. When defense says, well, look at the attorney, Mr. Ireland, he did not express fear. He did not interrupt or disengage. In the 12-minute conversation, it was 1 minute and 25 seconds after being threatened by the defendant that his attorney, his own attorney, says, get out of my office. Subsequent to that, this attorney paid for active shooter training for everyone at his office, paid for them to become familiar with guns, concealed carry, locked the doors to his office. The defendant scared this man, and that is the state's argument. This is not protected speech. It was intended to make a response. It does not matter if he intended to carry it out. The intent is to place the public in fear. It was directed to a specific date. We entered that Wednesday court date in the civil courthouse. It was, it was not a joke. It was not to be taken lightly. On that same case before the court, if we may go to page 3, defense spoke of lack of mens rea. Paranoia is not a criminal element. This conversation was more than exploring conspiracies against the defendant. This was not a private emotional procession or communication with the attorney. This is more than delusional, exaggerated, and distressed. It was a terroristic threat. He was not seeking knowledge. He wanted a reaction. Was it to light a fire? Who knows? But the fear was more than just at the office. It is at the courtroom. It involved the families involved in the civil proceeding. This type of language is not protected under the First Amendment. It is a true threat, and therefore defense's point number 5 should be denied as well.
All right, this is what the court is going to do. The motion to dismiss is denied. The motion to suppress is denied. I'm going to schedule this for a jury trial for September 30th. And so if there are more motions for the court to hear, please bring your motions before that date. Ms. Ferguson will make sure that it is placed on the docket.
Judge, is there any possibility that I can re-urge my motion to reduce bond
Yes.
at this time?
Well,
And
not
I'd
at
like to ask for that because
not at this time, but if the state has no objection, we can do it later in the week.
The state would object.
All right. So you'll have to give them their 10-day notice. Or I'm sorry, state, how much time do you need? You need less than 10 days?
For the reduction,
Yes.
we would.
All right. So if you all will confer on a date with Ms. Ferguson.
Yes, Judge.
All right. And then we'll go from there, okay?
Okay.
All right. They may be able to do it sooner. Amanda Ellis. Yes.
For a reset.
So, choices. We can continue with Boyd. Or we could go unknown. Let me show you what I mean. We have, 30 minutes to an hour left. And I have this. I have 3. I want to show you 3 different things. I want to show you one thing.
Go back.
Okay. We can watch his docket. I'm just going to forward it for a bit so we can see what goes on. Oh, never mind. Never the mind. There's only one little case in that whole 6-hour clip. Let me see.
Voice can be on the record.
And that's, I tried recording this in case I missed it. So I didn't. I mean, in case you took it down.
Current dates right
Okay.
now.
We can watch Riggins, whom I love. I made a video of her though. So we can watch Riggins to finish out the docket, or Boyd. Riggins or Boyd? Which would you prefer? I can't give you Eric. He hasn't streamed in days. Maybe he's on vacation. I don't know. But he hasn't streamed in a while. Riggins? We'll give Riggins a try, only because he's exclusive to here. Nobody else plays Riggins that I know of. No one. There's a couple other courtrooms that look like this. So, and I don't even know if anybody plays those other courtrooms. I just don't think they do. I think this is exclusive to here. Josh, you spelled it wrong. I don't have Georgia. They haven't streamed in days either. They used to stream all the time. He's really cool, and he's firm, and he's hard. So he's really good.
A dozen or more people present, and so we've been working to coordinate tape statements of as many of
And you
those
can
witnesses
hear.
as we can find.
Have you
tracking them
taken
down.
any yet?
Haven't tracked anybody down yet. We'll need investigative help to get those people. Jason sent me a list. We're gonna go through that list.
Sometimes it's hard to hear the prosecutor, but the prosecutor is awesome. He really does a great job.
Yeah.
I'd like to get this thing moving along, you know, especially since he's on probation or something. When that was, I really want to, yeah. Why are we having trouble finding these people?
When you sent me that, I think, when did you send me that? I can't remember. A couple weeks ago or so. It took a while to get the list of names because a lot of the people were reflected in the probable cause affidavit. I think if we have one more go around, we'll get it done.
All right. Is his dad here? He's normally here, so
I can check.
yeah, check this out. I want him to know what's going on, so because he normally comes, so.
I could not get over. I just that 3 a.m. call.
Kids aren't staying with you at your parents' house? How old are the older ones? All right, I'll appoint a public defender to represent you. You're gonna have to help pay for part of it, though. You understand that? Mhm. All right. We set the matter for September 15th, 8:30 a.m. for final pretrial, jury trial, September 22nd. The one that doesn't pay support, is he the father of two of the children? Right, but he doesn't keep them all the time, right? Does he help you with expenses? Okay, so he is contributing towards, just not by court order. Okay, all right, good. All right, I was gonna say, you don't need to raise these kids financially by yourself. Okay, and you understand, you can always go to the child support office in the county, which Shelby County is where you live, or I assume you're trying to get a home here.
Yeah.
So if at some point they stop paying or things fall apart, you go to the child support office and they'll assist you in receiving support. You understand that? Here's information. Contact the public defender's office, give it a day or two, and then go from there. Okay? All right, that'll conclude your hearing.
Thank you.
Thank you. Call for Larry Weber. You're welcome. Come on up, Mr. Weber. Have your appearance form, please. Thank you, Larry. Have you hired an attorney, Larry?
I have yet not yet retained it. I'm waiting for a formal introduction.
What do you mean?
He's supposed to introduce me to it. But I haven't.
Well, you don't need a friend to introduce you. You just pick up the phone and you call them, say, I've got money. You want to be my lawyer? And they'll say yes or no.
I understand. Also, he's also supposed to give me some money to do that for him.
So your friend's going to front the lawyer.
Correct.
Do you know who this lawyer is?
Didn't catch his name. It's his attorney's brother.
His attorney's brother, who also is a lawyer?
Yeah. It sounds crazy.
Well, no, well, but yeah, that's what I've got to find out. Make sure, you know, we're actually dealing with lawyers here. All right, well, it's not that old of a case. So I'm going to keep your final pretrial for August 11th. We'll see if you've got somebody hired by then. Do you work?
Yes.
We're just going to keep the dates. August 11th, August 18th. What do you do for a living?
Owner operator.
Over the road or local? Local, okay. You get paid by the mile or you get hourly?
By the load.
By the load.
It depends on mileage, depends on weight. Depends.
You drive a dump truck or?
No, it's a straight truck.
Oh, okay. Okay. All right. Well, talk to the lawyer's brother. Get it figured out. Okay.
All right, thank you.
All right. We'll see you then. Carter Hale. Up here, please, Carter. Do you have your appearance form? Thank you. Have you hired an attorney?
I have not.
Why not?
I don't have enough money at the moment.
Do you work?
I got the job at Knopf recently,
When did you start there?
July 7th.
Well, you've surely received a paycheck or two by now.
Yeah, I have, but I had to pay for food and stuff like that.
Do you live by yourself?
I do not.
Who do you live with?
My mom and dad.
Do you pay rent?
I do not.
So how much was your first check?
997 was some change.
So you ate $900 worth of food living with your parents between now and then and didn't have a dime to put towards getting a lawyer? Seems like you're eating a lot of steak or something there, Carter.
No, I was paying for the food bills.
For who? For the whole family or just you?
Yeah, for the whole family.
Well,
And I had to pay my brother my phone bills, which I have been paying.
phone bills. You have multiple phone bills or you have multiple phones? Or
No, only one.
do you have an opportunity to work overtime at Knopf?
Yes, that's what I've been doing. I'm saving up for a car.
Car. Then where's the lawyer fall? food, phone, car. Where's the lawyer fall in this thing? Are we at the bottom?
No,
How many of those things can you go to jail if you don't pay a phone bill?
no,
Can you go to jail if you don't pay a car bill? Can you go to jail if you don't pay a food bill? Can you go to jail in this case?
yes, sir.
If you go to jail, you're going to be able to keep that job at Knopf?
No.
So it seems to me getting a lawyer probably ought to move up the rank.
Okay.
Right?
Mhm.
Yes?
Yes, sir.
I'm going to reset this. You better have a lawyer hired. There's no excuse for you not to have a lawyer hired. If you're working at Knopf, if you're living with your parents, East 200 North. You can get a ride or you can ride a bicycle to work if you have to from Knopf. You don't need a car. You got something for him? All right. So the state is willing to offer you a diversion, meaning you don't have to get a lawyer. You can represent yourself in this if that's what you wish to do. All right. And what a diversion is, sorry, I'm getting a fire call. I forgot to take my phone off. Silence this. All right. So what can happen is you admit you screwed up, behave yourself for 6 months. Is that what it's going to be for, Ed?
Yeah, it's been 6 months and 20 hours of work. So.
All right. Do 20 hours of community service. You get that done, get it paid, it gets dismissed. Is that what you're interested in doing that? Is that a yes? Not, you have to say yes or no. We record. So
Yes, sir.
yes. All right. So by doing this, you are choosing to represent yourself. You don't have a lawyer. That way you don't have to get a.
Bill's here. Hi, Bill. Are you driving while texting? I'm going to turn you in if you are. I happen to know, sugar. What do you call the people that mandatory reporters? That's not the right word. Like if they hear a crime, they have to report it. I mean, I'm sure we all have to report crimes, but oh gosh, what is the word, guys? I hate getting old. I know the words. Mandatory reporter, which is just not the word, but you get the drift of where my mind is trying to go. I happen to know a little powerhouse from Harris County, Texas, who is a manual reporter. So if you are texting while you're driving, I am telling on you. And she has some knuckle sandwiches right for you.
Lawyer, you don't have to pay for the lawyer. You understand that? Yes.
Yes, sir.
Yes. Okay. We record this. Nods don't record. Okay. Yes. All right. You understand you don't have to do this. I'm willing to let you go get a lawyer and your lawyer can come back and negotiate. But frankly, he'd probably make the same offer to a lawyer too. So, all right. Okay. Have a seat. Wait for Ed to draw it up. Read it. And if that's what you want to do, sign it and bring it back to me. Okay.
Okay.
All right. He's got it right there. All right. Okay.
I like Ed. He's
Somebody
a
else
good
ready?
prosecutor.
Hang on.
Yeah.
I'm dealing with the lawyers.
There it is.
Yeah.
Me? Okay.
Yeah, I'm
Yeah.
waiting, I'm waiting.
All right. Ready for Heather Butler.
Okay. Okay. All right. 73 DO2 2506 F6 145, State of Indiana versus Heather Butler Kindred. Jason Clark appears. So what are we doing?
Judge, I believe the state still needs labs on this.
This is a little odd. Yes, this is a new judge. This is David Riggins. I'm 1,000% positive I have showed him before. Just me. I don't know anybody else who has showed him before, but it's rare. And the reason why it's rare is because the audio is not always the best. The prosecutor is a little hard to hear sometimes. And if they talk quiet or if they step back a little bit, it's hard to hear them. However, you can hear Riggins perfectly, and he is so freaking good, and he is so strict. Oh my, is that the Alamo behind it? No, that's not. So this is Indiana. And why does she have a jacket on? And why does he have a jacket on? I know for a fact Indiana was damn hot today or yesterday. I didn't record this like 8 months ago. This is from this week. So it's just a lot of clothes for Indiana, I feel. Jen, hi Jen. All right.
We've received his initial discovery, and Mr. Zick and I have talked about a couple different ways to resolve this. We do expect this to be resolved
Okay.
through a trial, so we just ask for.
All right. We'll show a continuance on the state's behalf then to September 15th, 8:30 a.m. Jury trial September 22nd.
AC is cold. Cold-hearted?
All right, Heather, did you fill out an appearance form for me? No,
They're outside. We'll have it.
fill one out before you leave.
Okay.
All right, and then I want it before you leave. Okay.
Okay.
Every time you come to court, my court, Heather, you need to fill out. It's like going to the doctor's office. You always got to fill one out every time. Even if the information's the same, I still want it.
Okay.
Because usually something changes, a phone, an email, an address, whatever. I just want it every time. Okay?
All right.
Grab one, fill it out, and give it to me when you're done. Okay?
Thank you.
All right, thank you, Heather.
Look at those lawyers working hard. Look at them. I'm glad I don't have a job that hard.
Okay, Carter, come on up.
Maiko is
All right,
the
so this is what you want to do.
100%.
Did you read it?
I did not read, but I was listening thoroughly. Here's waiting.
He's gonna
Carter,
make you
sit
go
down.
read it.
This is a legal document that deals with your future with a criminal case. Sit down and read it. Okay. Ed's not going to mislead you on purpose, but you need to make sure you read. Anytime a lawyer hands you something, you read it. And if you don't have questions, you ask. If you don't have understanding of it, you ask questions. Do you understand that?
Yes, sir.
Sit down and read it.
They always tell him they didn't read it, and he always makes them go read it. And he's gonna watch him.
Who is
he's
that
gonna make
gentleman
sure
that
his
was sitting
eyes
in
are
the back?
moving.
Yes, Tyler appointed in a separate case.
Okay.
I imagine he may get.
Tyler today. Okay.
Mr. Beckwith.
Very good.
We have reached agreement with state.
Okay.
Mr. Beckwith is going to be entering an open plea, so we're going to be asking for sentencing date about 60 days out. He's on
Can do that.
treatment.
Perfect. All right, Jeffrey, raise your right hand. You affirm that the pains and penalties of perjury testimony you're about to give is the truth, the whole truth, and nothing but the truth. All right, tell me your name.
I don't care how cold it is in these buildings. People, when it's this hot out and I have to go outside to go get something, people are damn lucky I have pants on. They just are. They just are because it's so freaking hot.
Date of birth?
7/25/1971.
You read, write, and understand the English language. What's the highest level of education you've obtained? Read this agreement, signed it, understand it. Okay, you're pleading open to operating a vehicle while being an HTV, is that correct? And they are dismissing the OVWI count, is that correct?
Yes. Yeah.
Oh, it was already dismissed?
Yeah. I think at the last pretrial conference.
Okay. All right. And was that because of evidentiary issues?
No, yeah, it was well within the 0.08, well over.
Okay. All right. Well, I get the reason I ask is, because it was still dismissed, even though it was lower, they still could have tried it. And so paragraph 14 is going to stick because there was consideration given, is my understanding. My point is under paragraph 14 on this, Jeffrey, normally on an completely open plea, you get to appeal my sentencing decision. In this case, you do not. You understand that? Yeah. You're stuck with whatever I give you. Okay. All right. You're giving up other constitutional rights, Jeffrey, by doing this. You understand that? You're given the right to an early public trial here in the county where the offense occurred. You're given the right to trial to the bench or to the jury. As I said, you had a jury trial. We'd have put 6 folks in the jury box. They alone decided if you were guilty or not. At the trial, you would have been presumed innocent. You'd have had the right to remain silent. You'd have had the right to have the state prove your guilt beyond a reasonable doubt. You'd have the right to confront and cross-examine witnesses against you and to subpoena witnesses to testify on your behalf. You'd have the right to appeal any conviction entered against you as well as any sentence imposed upon you. Because you are pleading guilty today, you're giving up all those rights. Do you understand this? See, by forced, threatened, or coerced you to do this. Anybody promised you anything? This is what you want to do. All right. How do you plead then to operating a vehicle while being a judge of habitual traffic violator? Guilty or not guilty? Guilty. You were driving and operating a motor vehicle in the streets of Shelby County, Indiana on about February 28th of 2025. Is that correct? And your license were validly suspended under Indiana Code 93010. Is that correct? That means you were a habitual traffic violator. You're suspended for that. And you knew that, correct? Where were you driving to that day? Yeah, and I know that doesn't surprise me. You're not the only one, Jeffrey. All right. Upon your plea of guilty, then I will find you guilty. I'll find your plea to be knowing, intelligent, and voluntary, and there's a factual basis in your judgment of conviction for operating a vehicle while being HTV. Do you want to do a PSI as well? I'd be inclined to.
I think it would be beneficial. You're right.
All right.
Yeah.
Okay. All right. I'll order a pre-sentence investigation and set the matter for sentencing. You're asking for about 60 days.
Yeah, Your Honor, 60 to 90. Mr. Beckwith is currently enrolled in Thinking for a Change program that he has about 6 weeks left, as well as some additional outpatient treatment. So he thinks he'll be done with all that at 60 days. So 60, 75 days.
Let's do October 7th, subject to a jury trial. It's a jury trial Tuesday, jury trial day. But
Okay.
as long as the jury trial doesn't go, we'll do it. And if I had to, I could even delay the jury coming back the next morning a little bit if we needed to.
What time?
8:30. Obviously, what happens between now and then, the state's going to bring up if it's bad. If it's good, obviously your attorney can bring up. So you need to make sure you try and impress me between now and then. Okay. Okay. Obviously, that means no driving. All right. There you go. All right, Jeffrey. Thank you, sir.
Thanks, Your Honor.
Uh-huh. You had a copy of that for you, right?
Yes.
Yeah. Who do you want me to call up, Brady?
Matthew.
All right. Come on up, Matthew. You have your appearance form?
Yes, sir.
Thank you. Raise your right hand. You affirm that the penalty of perjury testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Tell me your name.
Matthew Cross.
Date of birth.
9/10/1996.
Do you read, write, and understand the English language?
Yes, sir.
What's the highest level of education you've obtained? Okay. You read this agreement?
Yes, sir.
Signed it?
Yes, sir.
Understand it?
Yes, sir.
Do you have any questions about it?
No.
I'm not a party to it. All I can do is accept it or reject it. If I accept it, I'm bound by it. If I reject it, you go back and renegotiate or have your trial. Do you understand that?
Yes, sir.
This agreement says you're pleading guilty to possession of methamphetamine as a level 6 felony. You're getting 545 days. It's all suspended to probation except for 2 days. You've already got that time served. So you understand the plea bargain agreement.
Yes, sir.
Terms and conditions of probation include the following. Do not commit another offense. If you're arrested or charged with any offense, report that to a probation officer within 24 hours of the arrest or contact with law enforcement. Do you understand that? Report to any jail as ordered, pay any fines, fees, and costs as ordered. Submit to assessment and treatment if deemed necessary to inpatient, outpatient programs as designated by your probation officer. Report to probation as directed. Notify them in writing or telephone within 24 hours of change of address, telephone number, employment, or email. Understand that?
Yes, sir.
Do not use any controlled substance or mind-altering substance unless prescribed by your physician in the regular course of treatment. Immediately submit to random drug and alcohol screens at your expense from custody probation. Submit to warrantless and or suspicious searches of your person, your residence, your motor vehicle, your property by probation, law enforcement, or community corrections personnel at such times and places in the sole discretion of such personnel. Obtain, maintain employment, obey driving restrictions, not consume, possess alcohol, do not be in bars or taverns, do an ADA assessment, comply with it, and pay for it. No AMS, and this is consecutive to 73 DO2 2504 CM 185. Now, are we resolving that matter today as well, or you don't represent him on that, do you, Brady?
No.
Who represents you in that case?
All they really, 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 really need to know is, can you read and write? So they're hoping they say past the 6th grade or anything like that. Anything below there, the judge will probably make the lawyer read the paper to them.
Yeah,
Yeah, that's already decided.
that's already been decided. Is that with Warren?
Yeah. Yeah.
Okay, all
We
right,
decided that, it was either last week or.
okay, okay. All right, are you on probation for that or anything, or is just time served, you're
No,
done?
yeah,
Okay, all right. Is that your understanding of the plea bargain agreement?
yes.
All right,
I do have one question.
sure, go ahead.
So I'm currently on like pretrial release through Shelby County Correction.
Right,
So
that will terminate.
that will terminate today.
Mhm,
Okay,
yeah,
thank
yeah,
you.
but you'll start probation.
Yes, sir.
Because I'm not gonna go forward with it, but this was set for bond modification because you didn't comply with terms and conditions of that is the allegation. You understand
Yes,
that?
Your Honor. I missed the meeting that I had scheduled with my corrections officer. All I can tell you is that, I mean,
Come on, are you kidding me, guys? He missed one meeting. We see people in here that have violated 100 times, 400 times, 700 times. He missed a meeting.
honesty is key here,
It is, because
getting
you're
my
under
head on
oath.
straight and, being in the, putting my foot forward in the right direction. I understand that's a funny way of showing it. It's just, I've been working. My girlfriend, she's 8.5 months pregnant right now. We're expecting, we have doctor appointments every week. Life's crazy.
It's not gonna get any better once the baby's here,
I know it's not.
right, Brady? The new father, yeah,
That's right. I
yeah,
admittedly made the mistake of, forgetting the appointment
okay.
and.
Well, I'm not gonna do anything about it today,
I know-
but I'm just telling you,
I just-
the consequences of this violation are that I revoke your modify your bond. The
Absolutely.
consequences of violating this is up to 543 days in jail.
Yes.
You understand that?
I do understand.
And the burden is completely different. It's by preponderance of the evidence. Hearsay is admissible. It's a pretty loose hearing as compared to what you expect in a trial. You understand
Yes,
that? Okay. Now, is anybody forced, threatened, or coerced you to do this? Anybody promised you anything? Are you on probation or parole in any other cases? This is what you want to do.
Yes, sir.
And you're sober today, Matthew.
Yes, sir.
Is there anything about you mentally, emotionally, physically stopping you from understanding what you're doing today? You understand I'm not a party to the agreement. All I can do is accept it or reject it. If I accept it, I'm bound by it. If I reject it, you can go back and renegotiate or have your trial. Do you understand that?
Yes.
You went over the agreement with your attorney, Brady.
Yes.
You happy with Mr. Quackenbush's representation?
Great.
Is there anything you wanted him to do he has not done? All right. And you understand it would be a defense to this if you had a prescription. You understand that?
Great.
You can have a prescription for methamphetamine. It's a controlled substance, but it's not a level 1. It's a schedule 2. Did you have a prescription for methamphetamine?
No.
Okay. All right. How do you plead then to possession of methamphetamine as a level 6 felony? Guilty or not guilty? Did you knowingly possess methamphetamine in Shelby County, Indiana on or about May 20th of 2025?
Yes, sir.
All right. Find your plea guilty. I'll find you guilty. I'll find your plea to be knowing, intelligent, voluntary, and there's a factual basis under judgment conviction of possession of methamphetamine as a level 6 felony. Sent you to 545 days, suspend all but 2 days, give you credit for 1 + 1 day served, or you pay 189 in court costs. Be on probation for 543 days on the terms and conditions as previously discussed. You live in Marion County, but you keep getting arrested down here. Why you keep coming to Shelby County?
So, we were living in Shelby County,
Who's we?
me and my girlfriend, and we since moved to Decatur. And obviously, when I got arrested, and made some mistakes,
You moved to Decatur County, you said?
we had moved to Decatur
Okay.
County, and we decided that it would be best, while I'm getting my head on straight and showing you know, with actions, not just, you know, words, that I'm ready to make a change for the better. You know, and her parents holding me accountable for, you know, my actions, that I moved in with my brother in Marion County.
What's your brother do?
He's an electrician also.
Was that when you work with him at that Rinder?
Yes, sir.
What do you do for them?
I'm an electrician.
Is that what your training is as an electrician, or?
I mean, I'm not really in training anymore. I've been in the trade since I was 18.
Okay, so you're a journeyman, or?
No.
Okay, but you've been doing it long enough.
Yes.
You know what you're doing.
Yes, sir.
You make good money then.
I make fair money.
Oh, you should. I mean, you know,
I work for a
electricians.
small company.
Yeah, I
Small
understand.
family-owned company.
Okay. Is this primary new work, or is this going in and new construction?
We do a lot of service work. We do some new construction. We do some remodel. You know,
So,
I work for a family friend. He's only been in business for 4 years, and he hasn't really established whether he's going to do, you know, new construction, or we're doing a little bit of everything.
okay, you're starting out. All right. So you said you're going to be father in about a month or less.
Yeah, that'll be my second child.
You going to live with the mother, or?
That is the game plan. So
She lives in Decatur.
She lives in Decatur, so hopefully I'll be moving back to Decatur.
All right. Well, I'm going to keep her probation here then. So, because you're going to pass through here, going up to Indy to work, and if you live in Decatur County, plus you keep committing all the offenses here, and I want to make sure that we can keep an eye on you. So you can do tasks, you know, like if your ADA, if you've got a recommendation for a certain thing, you don't have to do that here in Shelby County. You can do wherever fits your schedule, but I'm going to keep your probation here. Okay. Do you still owe for fees for your pretrial?
I believe so, yes.
Well, if you do, I want them paid as condition of your probation as well. Do you understand that? When did you start doing that? Roughly, I don't need.
Okay, I'm just trying to be as honest.
Yeah.
You know, probably about 3 years ago, and I haven't been inconsistent.
Why'd you start, you think?
I wouldn't say necessarily peer pressure as much as curiosity.
Okay, fair enough. All right. Does the mother of your first child, do you have contact with her, and
I do.
You pay support for that first child?
I do.
Was she a meth user as well, or
She,
what about the current mother? Does she have a substance abuse problem?
she had previously had a substance abuse problem.
Okay, so you guys are gonna have to fight this battle together then, right?
Yeah, I mean, thankfully for me, she's got a lot more, you know, goodwill in her than I do. And if I would have followed her path, you know, earlier on in her pregnancy, I wouldn't be here today.
Yeah.
Unfortunately, it was my weak mind and my bad decisions that led me here. And
Well, just don't repeat it, you know? So don't keep beating yourself up over this. You're paying your penalty now, and this is the penalty you're paying for it. So I don't want you to feel like you should beat yourself up over it, because I don't think you should, but I think you should do better.
I don't beat myself up for making a mistake. I beat myself up for letting people down that I shouldn't have.
Well, yeah, I get that. And that's good. The fact that you care about what other people think about you is a good quality, but you can't let that weigh you down either, you know?
I don't care what anybody thinks about me. I care what my family thinks.
Yeah, well, your family's your family. They're going to love you no matter what. You know, I had a cousin who's in the dirt up at Fairland because he quit using heroin and he overdosed. Still loved him, you know. I knew he had issues, knew he had problems. Didn't take away my love for my cousin, but you know, it makes me sad when I think about him up there. You know, but that's just the way it is. So your family's love for you is not going to change at all. But what they get excited about is when you have success. And so that's what I want you to do, is have that success. That's what all this is for. This is not just to set up Matthew Cross. So it's like, oh, we're waiting for him to, you know, so we can hammer him when he screws up. That is not what I want. I want you to do well and be successful and have a great life. How old are you, Matthew? You're 27?
About to be 28.
Yeah, so you're a young man. You got a whole life ahead of you. You got kids to raise. You can have a great life still, but you got to stay away from this stuff.
Absolutely.
you know, and I understand it's hard, and I understand there's a craving for it.
That would have to be a members only, because nobody would watch it. My numbers would tank. When I do marathons, my numbers just die. It takes me months to recover my numbers again once I do a marathon. And if there's no court videos at all, we would have to make it. This is a good time. Okay. We have two options for this. And all right, listen. So I've been streaming this live stream to YouTube and Twitch for a while. I'm specifically speaking about the Twitch part. The Twitch part for, over a year, every day, 4 hours. This stream and OJ, every day, 4 hours on Twitch and here. I think besides some of you guys who run into Twitch and play around sometimes, I think I've gotten 2 real viewers from Twitch. All right. So I'm not building on Twitch. I'm not making money on Twitch or anything like that. But I found something out yesterday. And I'm wondering if I should put effort into it for you guys. And I'll tell you why. So I think like half of you watching me have YouTube Premium. So you don't see ads. But the other half of you, you don't have YouTube Premium. So when you watch my stream, you have to sit through a bunch of ads, which is a pain in the butt. It really is. But that's how we make money. But there's a way that you can get around that. All right. If you have an Amazon Prime membership. So I am only talking to the people who come to the live streams. So like at 4:30 a.m. or just come to the live streams, whatever live stream you go to. And you have to sit through ads, and you have YouTube Premium. No. And then you have Amazon Prime. All right. Now, I don't know if there's enough people that are in that one category to move forward with this or not. But so I'm just going to ask you guys if you want me to or you don't. If you have Amazon Prime, you can subscribe to one Twitch channel for free a month. But it's not reoccurring. You have to go in every month and do this. If you do that, you can watch the Twitch stream with no ads, none, 0 ads. It's free for you. It's absolutely free. Now you see this little box right here? This comment box, I have all comments from Twitch and YouTube showing up. So you can still see and interact with the YouTube people. You can even, no, that would be stupid. Do you have you have the other browser? There is another browser you can get to where you don't see ads. Anyway, my Twitch is not ready for that. To do that, I need 15 more followers. And then I need 3 people to come to my live stream on Twitch 4 days in a 12-day period, I think. So if you are in that group, if you do not have YouTube Premium and you're stuck watching these damn ads, and you come to my live stream, because this won't work on Replay Crew. You have ads. There's nothing you can do about that on Twitch. And you have an Amazon Prime membership, and you want me to fix my Twitch so that you could watch this from Twitch instead in real time with no ads, let me know. Let us know in Discord, because then we can all work together. I need 15 more people and 3 people to watch for 4 days on Twitch. So it would be stupidly easy to set this up. But only if you guys would rather have the Twitch option, so you don't have to watch ads. It's up to you. If you are watching ads and you want me to do this so you don't have to watch ads, let me know. If you don't care, then if I don't hear anything, then I know nobody cares. So I'm just gonna ignore it. But I don't know. I just thought maybe it might help some of you who are stuck with ads, pain in the ass ads, or you could just get YouTube Premium. But it's free if you do Twitch. But okay, I'm gonna keep going.
And I understand that sometimes it's hour by hour, minute by minute, but you got to fight that.
You want me to be honest with you? I used to have that craving. I used to,
Yeah.
you know, it used to be hard. It's easy now.
Okay.
Being on the right side of it.
Well, good. That's good.
Seeing it, all I have to gain, and
Yeah.
you know.
But you got to do it for you first.
Oh, absolutely.
You know, it's not other people come up here and say, well, it's about my kids. No, you got to get yourself fixed first, and the kid part will come.
I'm doing it for me. And
Good.
then secondly, I'm doing it for my kids.
Yeah.
And thirdly, I'm doing it for my girlfriend.
Yeah. Okay. All right, Matthew. So today what's going to happen, you're going to read inside your sentencing order, then you're going to go over to probation and then get signed up for probation and follow their directions. Okay?
Okay.
All right. Any other questions?
Yeah. Is there any way I could like have until maybe tomorrow or the end of the week to sign up for probation, just due to the fact that I am trying to
I want you. I know, but just they're going to keep you at work. They're not going to toss you for this. They know you had court, so go. Now I want you to go today. They won't take long today to get signed up, but you're already here. Let's just do it now. Be done with it and then move on. Okay. And you can tell them and say, hey, can I come back? I'll let them make that call, but I want you to walk over there today. So okay. Yeah, $200 PD fee. So yeah. Okay. So have a seat over here, Matthew, and then go on over. Okay.
Yes,
all right. Good luck.
Thanks.
Yep.
Dave.
You have this. I don't know if that's the original.
Great.
Well, Jordan.
There's Twitch TV.
73DO2 2404 F6 139 State of the United States Jordan Anthony Davis. Mr. Davis appears by Brady Quackenbush. State appears by Ed Zick. Set today for the final pretrial.
Got an agreement with this one as well, Judge.
Very good. All right, Jordan, raise your right hand as best you can. Jordan's in custody. Do you affirm under pains and penalties of perjury testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, tell me your name.
Jordan Davis.
What's your date of birth?
91.
You read, write, and understand the English language. What's the highest level of education you've obtained? This agreement says you're admitting to possession of a narcotic drug. It would be a defense if you had a prescription. It'd be 180 days. It's a minimum sentence. It's all executed. You've got credit for 57 plus 57 days in. You understand that? So you've got 33 more days to do. Do you understand that? You have to pay 189 in court costs, $200 DAPIC fee as well. Do you understand that? We'll talk about that. I don't know. You might be indigent. So, all right. When you plead guilty, you give up constitutional rights. Those are in paragraph 17. You're given the right to an early public trial here in the county where the offense occurred, right to trial to the bench or to the jury. In this case, you had a jury trial. We'd have put 6 folks in the jury box. They alone would have decided if you were guilty or not. At the trial, you would have been presumed innocent. You'd have had the right to remain silent. You'd have had the right to have the state prove your guilt beyond a reasonable doubt. You'd have the right to confront and cross-examine witnesses against you and to subpoena witnesses to testify on your behalf. You'd have the right to appeal any conviction entered against you as well as any sentence imposed upon you. But by pleading guilty today, you're giving up all those rights. Do you understand that? Were you on probation or parole? Did you have cases pending anywhere else? All right, in Marion County? Yeah. And, I see there's warrant out there. Is that because you got arrested down here?
I just got already locked up.
Yeah, for driving while suspended out of Marion County. All right. Nobody forced, threatened, or coerced you to do this. Nobody promised you anything other than the agreement. How do you plead then to possession of a narcotic drug as a level 6 felony? That's you're not guilty. On April 12th of 2022, did you knowingly possess a narcotic drug in Shelby County, Indiana? Did you have a prescription for that narcotic drug? What was the drug, do you know? All right, but it had drug on it, white powder residue. And so was that cocaine, or do you know? You don't know. Okay. But you're confident it was a narcotic drug. Is that correct? All right. All right. Upon your plea of guilty, then I will find you guilty. I'll find the
Dude,
case
what
to
the
know and
hell are
intel.
you doing? They don't know what the drug is. Fight this. You can fight this one. This one. You can make them prove to you you did something wrong before you do it. I don't know. Maybe they do know, and just the judge doesn't know. And if he fights it, he'll get more time.
Voluntary, and there is a factual basis in your possession, conviction, judgment conviction for possession of narcotic drug is a level 6 felony. Under count 1, sent you to 180 days. You waived the PSI, I take it. Is that right? Okay. Sent you 180 days, all executed. I give you credit for 57 plus 57. Do you work, Jordan? Why not? Well, I understand that, but you haven't always had a warrant. What kind of work did you do when you don't have a warrant? Warehouse. All right. Were you doing that at the time of your arrest? Are you going to do that again when you get out? Try and get in the union?
Speak
What
up.
kind of union? For what? Welding? Do you have experience welding, or no? Just something you want to try? Okay, good. They're going to do drug screening. Yeah. How long you been abusing substances, Jordan? Why'd you start? Yeah, I understand that. Doesn't make it go. It makes it go away while you're high, but that's about it. When you wake up from it, you recover from it. There's
Thank
still
you
loss
so
is
much.
still
I
there,
appreciate
right?
it. Thank you.
Okay. All right. I don't know. Harvard's who you hang out with. Where are you guys going? The casino that night? Okay. Were you going there, or you already left it on your way? Okay. There's an allegation there may have been fentanyl involved. That's nasty.
Salinas, I don't know if you're watching this on Replay Crew, but Jen just got you a membership. Salinas.
Nasty stuff. You understand that, Jordan? People wake up dead from that all the time. So understand that. Cocaine and fentanyl. Guys that are making that stuff, they don't care about you. There's always one other guy out there who's going to use it and abuse it. So next time if you would do it again, it may be the last time you ever do it. See it all the time. I'm a volunteer fireman too, and an EMT. We get dispatched to overdoses all the time. Sometimes they don't make it. So, all right. Hope you're not one of those guys. So, I think he's indigent. I'm not going to impose court costs or anything like that. So, oh, he did? Well, man, I didn't know he had a bond sitting there. Did you fail to appear or something in my court? Yeah, he did. All right. Well, no, we'll take it all then. Not all the bond, but we'll take 189 out of the bond for court costs, $200 for countermeasure fee, and $300 for PD fee. Whoever posted it will get the balance back. So, all right, Jordan, do your time, be done, and hope things go better for you. Okay. All right.
Do your time, be done, and I hope things get better for you. I think my priest said that to me when I got married. It didn't get better for me. It did not. Did my time, though. Did my time. All right, guys, that's it. We're going to pop right over to OJ. Thank you so much for coming today. I really, really appreciate it. This judge had another lady come in where she did not get jail, and she had a meltdown, and her husband, after the judge is like, hey, shut up to her husband, gets thrown out of the courtroom. I just did it yesterday. Hold on, maybe I'll give you a link. Maybe a link would be better. But it's from this docket. It's like right up here a little bit. And I liked it. I liked this clip. I moved a mountain to try to get the sound way better. So, if you want to see a husband get yanked out of court after she did not get jail, wait till you hear everything that she did. And she's trying to become a drug counselor. Oh my God. Oh well, that's it. I'll see you all soon. I really will. I hope you guys have a great day. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Street tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no